lord, I am for the petitioner here, my lord. Mr. Chatterjee, Mr. Kushal Chatterjee is appearing for the opposite party. The parties are, my lord, settling the matter out of the court. The process is on, my lord. It's not just about the clauses, my lord, in the compromise, my lord, which is being filed or which is intended to be filed, my lord. But that is being finalized. So if my lord may kindly, my lord, direct the matter, my lord, to go out.
Ask your junior to be present because you know I do not allow mentioning of listed matters unless for upgradation urgency.
Right.
You ask your junior, but I will keep it next because Mr. Bhattacharya, you know, the settlement issue is a very complicated one.
Yes, yes, absolutely.
So if it is not under some pressure, you will forget, Mr. Chatterjee will forget, and moreover, your clients will forget.
No,
So,
today, in fact, my lord, the party is litigating, my lord. They are having a meeting, my lord.
let us see.
Better.
You ask, I will keep it next, say, next Monday or Tuesday.
Very well. My lord, kindly keep it next Monday or Tuesday, or my lord, we can come back, my lord.
Because otherwise,
at least, my lord, we can come back and apprise your lordship, my lord, as regards.
what is the matter? Partition suit?
This arises out of, my lord, lease of a premises, my lord, which is being run as a hotel. Now, there were disputes and differences, my lord, between the landlord and, my lord, the lessee. I am for the landlord. The lessee filed a title suit.
How could it be a title suit?
Filed a title suit to have got an order of injunction.
Because if it is for exclusively for
got an order of injunction after termination of the lease deed, my lord.
Because
and my lord, they continued without payment of any lease rent, my lord, for a period, my lord, of it's continuing till date, my lord. We filed an application under Order 7, Rule 11.
Is it a registered lease deed?
No, that is our contention. We filed an application under Order 7, Rule 11.
If it is not a registered lease deed, then probably Deepak Polymer will come into play. 106 notice. Yes. So in that situation, it will be an ordinary suit.
So I'll tell you, lordship, what happened. We took out an application under Order 7, Rule 11. Now that was rejected. Challenging that, we came up in revision. Well, the suit was stayed. We succeeded. Now thereafter, my lord, the parties, my lord, they thought it amicable, my lord, prudent to settle the dispute amicably beyond the court. Now, my lord, that process is on. In fact, my lord, for showing bona fide, my lord, my client, in fact, did not, my lord, owing to, my lord, the settlements, my lord, he did not, my lord, also pray for, my lord, extension.
Don't speak so high about your client. Your client has not paid the lease rent.
No. My client is the landlord. I am not receiving anything.
You are not receiving.
Yes. Well, let me come back next week, my lord. And maybe
You
I'll
ask
be there.
when it is called on because see, Mr. Chatterjee is also not online.
I just had a word with him also, my lord, 15 minutes back. But today is the first day. He must be also running around, my lord.
So when it is called on, I think I will be calling it. And the understanding you talk to Mr. Chatterjee.
Yes. I will inform, my lord.
Next week.
Great.
Item 53, this is. The mark for it.
My lord, may I have your lordship's kind indulgence, my lord?
Yes.
My lord, may I mention one division bench matter, my lord, which is very much urgent, my lord.
Division bench matter. Division bench matter. Please mention when the division bench sits.
Oh, sorry. Yes, my.
Item number 1 under civil motion.
Item number 1, my lord, I appear for the petitioner. This, my lord, is the question of preemption, my lord, is pending before the larger bench. Now, if your lordship kindly sees the order dated 24th of April 2024, passed by the Honorable Coordinate Bench.
Oh, preemption larger bench judgment has come.
No, my lord. Subject to correction because today, my lord, in the monthly list, the larger bench's list has been published. Because I could not find any order beyond July 2024. So while checking the monthly list, my lord, it is there. I saw it there, my lord.
take down. It is submitted.
And for the respondent.
It is submitted by the petitioner and not disputed by the opposite party. That the issue involved in this civil revisional application that an identical issue to the issue involved in this civil revisional application is pending before the larger bench. Full stop. In fact, full stop. In fact, by an order dated 20th February 2024, after considering this aspect, a coordinate bench had adjourned the matter. In the aforesaid facts and circumstances, let this matter go out of the list with liberty to the parties to mention once the issue is decided by the larger bench.
Grateful.
Item number 2.
I beg to appeal for the petitioner.
What is the matter?
This is an application for expeditious disposal of the suit pending before the landed civil judge in the application in Chile.
What is the suit about? Are you appealing for the respondent?
Only for expeditious, but court was lying vacant.
The difficulty is that if it has to be a direction of the court for expeditious hearing, then you have to serve the other side.
Yes, but petition has become infructuous because the court has already been joined and the evidence has already been started.
But take down. It is submitted by the petitioner that this revisional application was filed at a juncture when the court before which the suit was pending was lying vacant. The petitioner, being the plaintiff in the said suit, had therefore sought for a direction upon the judge, upon the charge court for expeditious hearing of the suit. It is submitted that the civil judge, junior division, which court? Shiliguri.
District Judge.
Is no more vacant and the trial of the suit has commenced. The revisional application therefore has become infructuous. The revision application is disposed of without passing any further.
Item number 3.
Shimon Shianov is appearing. Mr. Shimon Shianov is appearing.
Yes.
My lord, train, my lord, has been delayed, my lord. So if your lordship can take it up tomorrow.
Very well. Not to record.
Great.
লিখে রাখবে যেগুলো নট টুডে হচ্ছে না, লিখে রাখবে।
Item number 4. Item number 4.
Passover.
Item number 5. Item number 5.
Passover. লিখে রাখো পাস ওভার গুলো লিখে রাখবে।
Item number 6. Item number 6.
পাস ওভার,
Item number 7. Item number 7.
পাস ওভার,
Item number 8.
8 অনলাইন।
Item number 8.
Yes,
Yeah.
for the petitioner. basically.
Yes.
This is a, we have come before your honor, in a case where the matter was fixed ex parte against the respondent, opposite party. After taking 3 adjournments with the specific ground that they will be filing the case. Thereafter, the learned court below has fixed the matter in ex parte. On the date of next date, we filed our evidence in chief as P1, but that could not be taken into record. As because on that same date, the opposite party number 1 had filed another petition saying for an adjournment, and the learned court below, going beyond the principles of law,
What principles of law?
that is without having the, or vacating an application, vacating the ex parte order fixed against the petitioner. The learned court suo motu had vacated the order of ex parte on a petition which was meant for an adjournment. So we had come before this honorable court and
What do you want? Let us take bull by the horn. You are the plaintiff.
yes,
You want your suit to be heard expeditiously. Now it is not a commercial suit that the 120 days rigors will apply. 2002 amendment in respect of filing of written statement within 30 days has been diluted to the last hilt over the years.
yes.
So you cannot stop. Tomorrow, if you stop them from filing the written statement,
My
Your-
submission is,
your client's right is likely to be prejudiced more because
this is a suit for damage against malicious prosecution. So we cannot keep this suit at the same and cater it. everything.
what is the malicious prosecution?
They have maliciously implicated me in a case which I was condoned by the court after.
Very well.
So we are sure about the intention of the petitioners, of the respondents, their backbiting tendency or the malified intention against me. So now if we don't go for a strict,
What is the situation over there? Have they filed their written statement?
no, they have again on the next date sought for an adjournment
Very
for.
well. I think you can take instruction or you can here and now concede. I will give them 15 days time to file the written statement, and that will be the peremptory chance. If they do not file it within 15 days, no written statement should be taken on board.
But my lord, one little submission with your indulgence. This is a suit for malicious prosecution.
Maybe malicious prosecution.
No, this is not a.
In our country, malicious prosecution
That means the
is
wrong that
only-
they have done once.
is only in it was only in section 499 500 of the CRPC, now probably 513 or something like that.
I do.
And it is a action in tort.
I do.
So if you want if you try to persuade me that your suit, being a suit for prosecution, has to be set apart and placed in a different pedestal, I may initially agree, but end result, end result will be, have you seen the Supreme Court judgments? After 20 years, the delay is condoned and substitution allowed.
I got you.
Will it serve any practical purpose? Because you are trying to get it ex parte.
With your indulgence, my lord, that 15 days may be for 7 days and a time bomb that the suit should be disposed of within a time frame. This much indulgence because my lord, just see, I was headed for more than 3 years at a stretch, and here in this case, I
I'm not
5 occasions.
I am not going into the merits, whether you were heckled for rightful purpose or you are heckled without any rightful purpose. I'm not going into it because that is not the subject matter before me. The more you submit, ice will melt on the sympathetic ground.
My humble submission is that let that 15 days be shortened a bit, and time limit may be fixed for expeditious hearing and to finish off the matter.
How many defendants are there?
There are 5 defendants, all 4 ex parte, all 5 ex parte. Only one is appeared in the suit after receiving summons, and for the last 7 days, the same tactics has been practiced. But the learned court below shouldn't have vacated the ex parte order without a proper application, my lord. This much.
See, you are Mr.
I'm Dr. Povitra Palchur.
Mr. Palchoduri, with your experience, I think you will not disagree that these are mere technicalities. I always say, with my experience on that side,
As your lordship
go
pleases.
take the bull by the horn.
As your lordship pleases, but my humble submission would be let that 15
It
days
does not
period
see.
be shortened a bit and the time limit may be fixed.
In this branch, I can tell you, I have a little bit experience while in the bar because I predominantly did civil suits and trials. So I am aware it will not inure to your benefit.
Had it not been a suit for malicious prosecution, I wouldn't have submitted all so long.
The impugned order is dated 18th March 2025.
I beg your pardon.
Impugned order is 18th
18th of February 2020.
18th February or March.
Then March again, the opposite party defendant, he filed a petition for ex parte was vacated on 18th to 2020.
Take down. The petitioner is the plaintiff in a suit for malicious prosecution. The petitioner says that after being falsely implicated in a prosecution where the petitioner was honorably acquitted, the petitioner had filed this suit. In or about, when did you file this suit?
The suit was filed on
19th March 2024.
19th was on motion, yes.
19th March 2024. Full stop. There are 5 defendants. Defendants number 2, 5 has not entered appearance
Yes, from the first day.
and the suit has been marked to be proceeded
Ex parte against.
as an undefended suit. Where do you get this concept of ex parte?
So it goes to ex parte after 90 days.
Undefended suit. Undefended suit against the said defendant. Full stop. The suit was placed in the ex parte board as against defendant number 1, as the said defendant time and again sought for an adjournment to file written statement, but did not file the same. It is the case of the petitioner that without recalling the order by which the suit was placed in the ex parte board, the learned judge learned civil judge senior division, learned civil judge bracket is senior division Jalpaiguri, granted time to file written statement on an application made by on a simpliciter application
For adjournment.
for adjourn for
written statement on a
simpliciter application for adjournment made by the defendant number 1. Post. The petitioner therefore, being aggrieved by the order dated 18th February 2025, has filed this revisional application. It also appears that subsequent to the order of 18th February, a further order was passed on
That was on
18th
18th.
18th March 2025,
That day also they have sought for electron.
which is prior to the filing of this revisional application. By the said order dated 18th March 2025, the time to file written statement was extended till 22nd April 2025.
25 April.
Now, 22nd April 2025 as a last chance. Full stop. What happened on 24th April? What happened on 24th April?
The suit was stayed by this honorable court,
Ah.
so there was no proceeding at all. But the order dated first. Order dated.
Have you served? Have you served?
Yes, yes.
Where is the affidavit of
Everybody
right?
service is there, but it's coming, I'll just hand it over. It's getting signed.
See. However, prior to 22nd April, the the proceedings in connection with the said suit was stayed by this court by an order dated 8th April 2025 passed in the civil revisional application. Do you have a copy of the service that they have received it?
It's getting signed in the office and I'll supply it within 2-3 minutes.
The opposite parties remain unrepresented despite.
Report is here, I'm
That is what I am asking you. Show me the track report. Where is the postal receipt?
It's in the office, getting it endorsed.
Don't you have a copy of the postal receipt?
No, I don't have one with me.
See, handing
Just-
over this track report will not
I-
suffice because
That is why
EW
I was not handing it over.
EW number has to be
Yes,
to be tallied.
Kindly allow me 5 minutes.
Despite service. Okay. After hearing the petitioner and considering the materials on record, I find that no fruitful purpose will be served by staying the proceedings in the suit, as it will jeopardize, as it will cause further prejudice to the petitioner, being the plaintiff in the suit. Since the learned civil judge senior division at Jalpaiguri had given a last chance to file the written statement, I am inclined to extend the said time period peremptorily till till 23rd June 2025. It is made clear that in the event the defendant does not, defendant number 1 does not file, is defendant number 1 is his or her
Suman Sengupta. Sri Suman Sengupta.
It's made clear in the event the defendant does not find his written statement.
a written statement within 23rd June 2025. The the said defendant shall be precluded from filing his written statement. and the suit should be proceeded as an undefended suit as against the said defendant. As against the said defendant number one, full stop. The learned civil judge, senior division, Jalpaiguri, shall make an endeavor to dispose of this suit as expeditiously as possible, but without granting any unnecessary adjournment.
Why the other participant?
To either of the parties.
My lord, one small indulgence.
No objection.
The one indulgence. That is, we will be facing the same thing unless and until the district, unless and until the learned court below is pointed out the fault that she has made. Because without filing an vacating petition, she shouldn't have vacated the order based on an adjournment petition. So she has to learn. We are all learners in the court.
I am also learning.
That much should a small line to that effect should be there. Otherwise, we will be facing the same problem before the court below.
Mr. Pal Chaudhary, I am not sitting in a public interest domain. This is a dedicated. It is not a curative action.
No, I
If the learned judge does not does commit the same mistake, consequences will follow.
the only one line key, she should have vacated it with a proper application.
The first order
Anyway.
clearly says, see, your suit, you want it to be heard.
Definitely.
Whether she had committed a technical error or not, it is immaterial. Your object is to get it heard. The divisional application being such and such is accordingly disposed of.
I'll finally try.
Since the defendants are not appearing, let a copy of this order be served on the defendant. Defendants are not appearing. Let a copy of this order be served on the defendant number one, as also to the learned advocate representing the defendant number one before the district court at Jalpaiguri.
If they are possible, present disposal or already delivered.
The interim order as to stay of all proceedings in the suit is also vacated. See, it's so going. If the stay continues, it will go against.
So that I do understand, and I've objected to on the very first day also. So I'm handing over the affidavit of service, but Your Lordship, that one line would have made her learn the process of. She cannot go beyond the procedure.
I've recorded your submission.
With your
Item number 9.
Noted 9, I appeal for the petition.
Lord, I appear for the opposite party, Milord. Milord, it appears that a CAN application has been filed. Neither a copy has been served upon me.
That I'm
nor
not
upon
pressing
me.
for extension.
Yes.
That I'll not press.
What is the matter about?
Lord, I have agreed by an order passed by the arbitrator, whereby, Milord, my application for amendment of my statement of claim was denied. That is the crux of the matter, Milord. This arbitrator happened to be, Milord, appointed by this honorable court under section 11. And, Milord, the application is
To
that,
what extent divisional application will lie?
Milord, I have, to that effect, Milord,
To what extent? Tell me.
I have successfully argued before your Lordship an application whereby a similar, Milord, circumstance appeared before the DRT. And your Lordship was,
DRT was a different thing altogether. Now, under the scheme of arbitration, you show me that how do you come in a 227 for a
there is-
direction upon an arbitrator?
If there is manifest injustice, which is
Yes.
palpable in this particular case, Article 227 is very much open to. There are not caten of judgments to that effect.
Show
It's-
me.
It's a simple amendment.
Show me. I don't believe in here. You show me.
I'll show you.
And don't show me the archaic judgments.
No, Milord, a recent one.
I will pardon for them.
देखिए एक बार देखो এটা রেকর্ডে ওপরে দিয়ে দেবে না এফিডেভিট অফ সার্ভিস ফাইলিং কোর্স See, if you are ready,
Milord, just one day accommodation. But I've
very good.
not ready with that.
And what is the application? The scan for
Can was for extension, Milord. I'm not
extension for
extension of the interim order of stay passed of the arbitration.
you serving a copy. Why you
Yes,
go?
I'll-
You serving a copy. Come back tomorrow.
Yes,
Milord, can the matter taken up for final hearing tomorrow?
yes. I'm
Milord, matter is ready for hearing.
Yes, you come ready.
Milord, I am ready.
You have not objected to.
Milord, I am ready.
Show me the judgment. That 227 does not lie.
Yes, Milord.
Very well. Come tomorrow.
Tomorrow.
Don't show your cards today to me.
I'm ready.
Item number 10.
May it please your lordship.
Yes.
My lord, I am appearing on behalf of the petitioner subject to your lordship's approval.
The court cannot grant you approval. It is your client who has given you the vokalatnama to appear. So approval is by your client.
We are always,
The court will hear you or court may not hear you.
my lord, we are always supervision under the planet court or honorable court of law.
Very well. What is the matter about?
My lord, matter is husband filed a mat suit in Jalpaiguri court, whereas the opposite party resides at Parashat along with her two children, minor children. My lord, it is not possible for reach Jalpaiguri court to attend the proceeding.
You serve the husband?
Yes, served copy served. My lord, my learned brother is over there. The addressee himself received the copy.
Your client, the wife is staying at at her parental house or she's staying there for
Parental house.
parental house. Where have you stated so?
My lord, I have stated in my petition.
Where was the marriage? Where did the marriage take place?
My lord, Baguyhati.
What about the stay? Is the stay?
Stage is only for filing the WS. In the year of 2021, that matter was initiated by the petitioner before the learned district forum, and in the year of 2025, I have received the copy of the petition.
For item number 12, the extra paper on behalf of the opposite party.
Which one?
Well, item number 10. Item number 10.
This item? Yes, what do you say?
Well, the opposite party has been filed in the year of 2021 in a section 9 application for restitution of our conjugal rights, my lord.
Who?
My lord, the husband.
Yes.
My lord, thereafter they did not appear in the said application. And my lord, subsequently, when the lastly notice was served in the year of 2025, and my lord, thereafter they filed this application. My lord, their only intention is to delay the proceedings. And my lord, the opposite party number 2 had a my lord, has a my lord, my lord, physically handicapped wife, physically handicapped my lord, sister in her home, my lord. And my lord, he is the only one to look after. My lord, it is impossible for him to, my lord.
See, the law is very well settled. You cannot go beyond that. Don't try to make something a new case. It is always been the court where the wife resides. You may be aggrieved, I may be aggrieved, but the law is.
But my lord, this is the application of 2021, my lord.
Maybe.
After 4 years, my lord, they have been filed this present application, my lord.
Maybe.
My lord, in the year of 2000, they did not appear, my lord. They are only.
How much
interested in-
money did you pay your wife for the litigation cost?
My lord, I have to take instruction.
You have not paid a penny.
No.
Your face says so. Otherwise, your husband would have jumped up and instructed you. I have paid so many thousands of rupees for litigation cost. Nothing to do.
Not even single penny he has paid, my lord, for at least his children. As of now. And this is the first time service which has been happened by the petitioner.
So this is the case of 2021. It is a first service, my lord. My case has been disposed of by the learned trial court since long back, my lord.
What disposed of?
Dismissed, my lord. Because, my lord, this is a case of 2021. It is not my first summons.
No,
my lord, to the-
dismissed. Which case has been dismissed? The suit
lord,
has been
section-
dismissed.
My lord, the section 9. If, my lord, after 4 years I did not summons to the petitioner, my lord. My lord, the case may be dismissed by the learned trial court, my lord. It is
Let
not-
it be dismissed by the
No, my lord, not
competent court. Competent court.
Man.
See, I always in the principal court and over here I repeat, don't trigger my poisoned mind.
No.
I had a poisoned mind when I was on that side. I
personally
try to
forget-
forget everything and come back. 4 years a suit is pending. I take it, COVID intervened in between, so it was pending. The Peskar is being made happy. He is giving date 1 year, 9 months. Plain and simple. And you want to keep the suit pending because restitution of conjugal rights suit will be a check and guard to any action taken by the wife. Yes, this is an application under section 24 of the Code of Civil Procedure 1908, in short CPC, for transfer of a petition for restitution of conjugal right filed by the husband. This is an application by the wife under section 24. petition conjugal right filed before the district and session judge Jalpaiguri, being matrimonial suit number 553 of 2020. It is the case of the petitioner that the first notice which was served in the suit, in the aforesaid suit, was in the year 2025, pursuant to which this application for transfer of the suit has been made. On 9th April 2025. It is not in dispute. Now, the opposite party is represented. It is not in dispute that the first notice of the matrimonial suit was served only in the year 2025. It is the further case, এটা আলাদা করে দাও. It is the further case of the petition that the marriage between the petitioner and the opposite party took place at Kestopur in Kolkata. The parties resided as husband and wife in a rented accommodation at Kestopur. Subsequently, the relationship soured, which resulted in the petitioner staying at her at her parental abode with two minor children. Abode, minor children. The first child is a daughter aged about 12 years, which is from the first marriage of the petitioner. The second is a boy born out of the present wedlock on on 11 July 2020. Next, the opposite party resists the application for transfer on the ground that he has a challenged sister and the opposite party is the only caregiver. Caregiver. This reasoning, however, does not stand good when it is an admitted position that after the marriage, the petitioner, the opposite party stayed in a rented accommodation with the petitioner at Kestopo and not at Jalpaiguri, where the sister resides or resided. Next, after hearing the parties and considering the materials on record as also the legal provision, I find that the balance and convenience and inconvenience is overwhelmingly tilted towards the petitioner. With two minor children, it will be not only inconvenient, but may at times be an impossibility. May at times be an impossibility for the petitioner to come from Kolkata to Jalpaiguri to defend or proceed with the litigation. On the other hand, the opposite party, assuming without admitting is the caregiver of our challenged sister, may have to leave the station for a day or two to attend the proceedings. If the suit is transferred, where have you asked for transfer?
My lord, Landed Court of Barasha. Petitioner's jurisdiction is Barasha.
If the suit is transferred to the court of the Landed District Judge, 24 Parganas North. But I think it will come to this Bidhannagar court because
My lord, her jurisdiction is under the Landed.
it will ultimately it will come. It will come.
Yes.
In the aforesaid facts and circumstances, the mat suit number is 553 of 21, 553 of 2021, now pending before the Landed District and Sessions Judge, Jalpaiguri. Now pending.
FTC second court, my lord. Landed
Yes,
FTC
yes. Now pending before the Landed Fast Track Court, second court, Jalpaiguri, is transferred with all connected applications now pending to the court of the Landed District Judge, 24 Parganas North, System. The records of the proceedings shall be sent by the registry of the district court at Jalpaiguri within a period of 1 month to the court of the Landed District Judge at Barasha, bracketed not 24 Parganas.
My lord, if your lordship kindly allow me, may I pray one thing just?
Yes.
My lord, if your lord, my lord, she is a lady along with 2 children. It is not possible for her to communicate this solemn order by your lordship.
Please wait,
Second FTC court at Jalpaiguri. If your lordship kindly direct to the
Please wait.
register to serve the copy of the order to the learned consent.
See, after you have done the matter, you should have the patience to hear the order.
I'm sorry, my lord, extremely sorry, beg your lordship's pardon. Beg your lordship's pardon.
Before you allowed me to complete the order, you are making the
I'm
suggestion.
sorry, extremely sorry, my lord. Beg your
I am
lordship-
going to direct the same thing because the registry has to communicate.
My lord, I'm sorry, my lord, I'm sorry. I beg your lordship's pardon.
কি বললাম তোমাকে?
The proceedings shall be sent by the registry of the district judge Jalpaiguri.
The registry of this circuit bench is directed to communicate a copy of this order to the learned district and session judge Jalpaiguri, or the first track court সেটা and the learned ওই
District judge Barathana.
not 24 post. Nothing further remains to be adjudicated in this application. The revisional application is accordingly disposed of.
Profoundly, deeply obliged, my lord.
আচ্ছা, এফিডেভিট অফ সার্ভিসটা উপরে দিয়েছে সেটা রেখে দেবো। Very well, I think today we shall be going for a meeting now because the bar has proposed here. And after that, probably I will be sitting in the division bench. Now, for the bar members, I say that if the bail bench is heavy of Justice Chatterjee, then we may sit in the division bench, depending upon the situation, only in the second half. That,
complete.
Yes, any mentioning through virtual mode? Yes.
My lord, may I have your lordship's kind indulgence, my lord, to mention, my lord, one very urgent matter, my lord, regarding transfer of a group D staff. My lord, a female health assistant who has been transferred from Jalpaiguri to Dakshin Dinajpur, my lord, which is more than 300 kilometers away, my lord. Moreover, my lord, the mother of the petitioner, my lord, is now in very serious, precarious condition due to health at the age of 73. And there is none to look after her mother, my lord, to take care of her. And moreover, my lord, the petitioner is also suffering from various ailments, my lord, for which, my lord, during vacation.
Your challenge was unsuccessful, so you have preferred an appeal against that order.
No, my lord, not that. During vacation, my lord, as the tribunal was not functioning, my lord, so, my lord, I preferred it application, my lord, for hearing. But unfortunately, the government, in spite of service, did not appear on that day.
Now the tribunal is functioning.
My lord, what is happening? Again, you lordship knows, my lord, one man tribunal man is functioning for more than 3 years, my lord, more than 4 years, my lord, and it is very difficult, my lord, to get a matter heard, my lord, before the learned tribunal, my lord. If you lordship kindly, my lord, kindly see the. If you lordship kindly see.
What is the law? What is the law?
Law, my lord, they are saying that I have been transferred on detail matter.
No, law means what is the law that the jurisdictional high court will be hearing the matter?
Yes, my lord. I have judgment, my lord. I shall show the
Which
judgment, my lord.
judgment? Which judgment?
Man, constitution bench judgment, my lord.
Which one? Which one?
Page 392. Where, my lord, it says that
Page
if
392, which
tribunal
judgment?
is not functioning, or it is impossible to get any remedy from the tribunal
See,
does
you
not
have
function properly,
you
then
have
High
two
Court
judgments. You have two judgments on record which
My lord,
you can cite. One is Roger Matthews versus South Indian Bank. Another one is Samuel.
constitution bench judgment.
I can give you those judgments, no difficulty. But the fact is that the case has to be put into such a pedestal that there is no other alternative way but to hear it by the jurisdictional high court. Only in those cases the writ petition is entertained.
My lord, this is such a matter, my lord. What has happened, my lord?
And even then, it has to go before the single bench.
Yes, my lord, my lord, Justice Partha Chatterjee is sitting over there. My lord, I like to draw the kind attention of my Honorable Justice Partha Chatterjee, where I mentioned the matter. My lord had advised me to.
It has to go before this thing.
I cannot hear.
It has to, you have a writ court which is now presided over by Justice Kant. You have to go before that bench.
My lord, what has happened? My lord, your lordship has enough, my lord, power, my lord, and extraordinary jurisdiction, my lord.
No, see, the difficulty is that the tribunal order is in judicial review heard by a division bench. But you are coming under 226 on the ground that the tribunal is not operational or is virtually not in operation. So you have to file a writ petition before the single bench. You cannot come before the division bench.
I mentioned the matter before the Honorable Justice Partha Chatterjee, and my lord directed me to mention the matter before the division bench, my lord. So, my lord,
No,
alternative.
most probably your contention was that now tribunal is functioning with one member, and it is not being possible for that member to address all the matter, and hence you want to invoke the jurisdiction of.
My lord,
of
The
single
division
bench.
bench, my lord, heard the matter, entered into the merit of the case. But
Oh.
as my lord, learned junior advocate who was appearing on behalf of the state stated that his senior is not present, so he cannot answer to the questions my lord put to him.
According to me, the division,
করতে বলে।
the division bench does not have the authority to hear, because division bench hears a judicial review from an order of the tribunal. You have not gone before the tribunal. If you had gone before the tribunal, then probably the matter could be entertained by the division bench. If you had to come directly under 226, then you have to come before the judge having determination under group 6 service matter. Over there writ petition is maintainable, because this part I had clarified, because I was sitting in the group 6 bench for considerable period of time. You will find my orders are there. I have clarified this thing time and again, not in one matter, in many of the matters. Because see, there is a division bench judgment of presided over by Justice Bhanumati, and the judgment was delivered by Justice Indira Banerjee, as our ladyship was in the Supreme Court. It is reported in 2020, probably Supreme Court, Saurabh Gupta versus Ames. There, the bench took into account all these aspects and said that even if you are challenging the validity of any rule or statute, which is not the principal statute under which the administrative tribunal is constituted, then also you have to go before the administrative tribunal, be it the state administrative tribunal or the central administrative tribunal. I can give you the judgment if you want.
My lord, Supreme Court, my lord, in one judgment, my lord, held that where the tribunal cannot, my lord, consider the virus of
telling
the
you,
constitution.
No. Virus.
Yes.
Virus
Cannot
of the,
hear the matter where virus is challenged.
I do not agree with you.
Yes.
I do not agree with you, because I am giving you the judgment 2020, probably 12 SCC, Saurabh Gupta versus Ames.
My lord,
2020, 17 SCC 602. Saurabh Gupta versus Ames. You read that judgment, you will be clear on this issue.
my lord, will learn from your lordship, my lord, what has happened, my lord, Mr. Justice, Honorable Justice Tiwari, while presiding over the division bench, my lord, has entertained this matter, my lord, on the in the Eviction bench, only because the government was not appearing in on that day. So, my lord, his lordship could not pass the order. That is the difficulty, man.
Sorry.
Once, my lord, my lord, division bench entertained the matter.
No,
and
it is not a subject matter of the division bench. It is not a subject matter of the division bench. Division bench assumes jurisdiction if you come against a challenging an order of the tribunal in a judicial review. But the division bench does not have the authority to hear out an application where you are directly challenging an action by invoking the provisions of Article 226.
My lord, the division bench, my lord,
And
already
Justice Tiwari, he
Kapoor,
had
Justice Kapoor.
Ah.
Sorry, Justice Kapoor, my lord. Justice
he
Kapoor was
cannot
presiding
be.
over the division bench along with my lord Vishwarup Bhattacharya. My lord, if you lord,
Vishwarup Bhattacharya is, there is no judge by the name Vishwarup
no, sorry, my lord, Parthopratim Bhattacharya, my
Bhattacharya. There is no judge also of that by the name.
lord. Parthopratim Bhattacharya.
There is no judge by that name. Don't confuse yourself. You look
So,
into
my
the
lord, I am sorry, my lord, I beg apology, my lord.
Sorry, you look into the legal provisions and then you come back. I have given
tender
you
apology, my lord.
I have given you the judgments. Roger Matthews versus South India Bank, Samuel Matthews versus South Indian Bank, and I have given you the judgment of Saurav Gupta versus Ames. Please read the judgment and then you come back.
My lord, what has happened, my lord? Once, my lord, the division bench entertained the matter, my lord, and directed to be listed today.
I am very well. If it is listed, I will dismiss your application because I am of the view, and my brother is also agreeing with me, that the division bench does not have the jurisdiction to entertain a matter. See, the Ram is not born, you are asking for Ramayana. I could appreciate that you had gone before the tribunal had passed some order, you are challenging it may be an adjournment order, it may have posted the matter after 2 months. Challenging that order, you have come before the court. Your application under judicial review before.
Tribunal was not functioning properly, not properly meant such and such.
That
That problem you can 227, the division bench who is taking tribunal application, 227 POCT or SPSP, go that.
পারবে না, ওটা পারবে না। কারণ কি, দেখো, অরিজিনটা হচ্ছে ট্রাইব্যুনালে তুমি ফাইল করলে, ট্রাইব্যুনালে কি হয়, যখন ফাইল করলে রেজিস্টার একটা হচ্ছে ইয়ে দেয় যে অমুক বেঞ্চে যাবে, প্রথম অর্ডারটা রেজিস্টার দেয় অমুক বেঞ্চে যাবে অমুক তারিখ। এইবারে সে যদি শুনে কোনো অর্ডার দেয়, ধরো অ্যাডজার্ন করে দিল, you are agreed by that order, then you can come before the division bench. But if you say that the tribunal is not functioning,
Yes.
then you have to invoke 226 following the provisions of Roger Matthews before the jurisdictional high court, that will be before the single bench.
Okay, Roger.
That has to be before the single bench.
I mentioned the matter before.
Without jurisdiction হয়ে যাবে।
Okay, so ম্যাটারটা প্লেস করুন, সেটা অর্ডার
My lord, kindly, my lord, list the matter, my lord. Then, my lord, I shall try my luck, my lord. If you lordship, kindly, my lord.
Very well.
Tomorrow, my lord. Tomorrow, my lord.
I will look into it. If the file is available, it will be.
Yes.
Who is on your other side?
Other side, my lord, Mr. Sopon Banerjee. Sopon Banerjee was
the
assigned
state.
and his junior appeared, but in the order it is said that none appeared
See, you are mentioning
for
it.
the state. I
See,
shall.
You inform Mr. Banerjee, we will be keeping it day after tomorrow.
Yes, ma'am. Yes, ma'am. I am grateful, ma'am. I am grateful, ma'am.
You give the case number.
Yes, my lord. Yeah, my junior is there, my lord. He is producing the slip.
Who is your junior? No one is to be found here.
My lord, it will be given, my lord.
যদি দেয় তাহলে কোনো কেউ এসে যদি দেয় তো নিয়ে নেবে।
Yes, my lord. Yes, my lord.
করণ, মিস্টার করণ যে ম্যাটারটা মেনশন করেছিল, এটা তার নাম্বার। Yes.
তারক
Much grateful, my lord.
দেবব্রত করণ, ডক্টর।
My lord, I am grateful, my lord. Much obliged, my lord. I am very much grateful, my lord.
Day after tomorrow.
Yes, ma'am. I am very much grateful, ma'am.
Yes.
Lordships, may I beg to mention one matter. This matter is pertaining to the interim application, interim maintenance application I have filed in the appeal application. Lordship, I am having no source of income.
How was the appeal originated?
It's originated from a divorce suit out of an order and judgment, Lordship.
What judgment?
The divorce has been passed in favor of the respondent herein, Lordship.
Respondent,
Under the Hindu Marriage Act. Where
respondent is the wife or the husband?
Respondent is the husband. I'm for the wife, Lordship.
You're for the wife.
Yes.
Now, in the divorce suit, there was a direction for payment of interim maintenance.
No, Lordship. In the divorce suit, arising out of divorce suit, judgment was passed. Judgment and a decree was passed divorcing the wife and the
It's
husband.
annulling the marriage.
Yes.
Annulling the marriage.
Yes, sir. So out of the judgment, I have filed this appeal because the judgment was passed in terms of Hindu Marriage Act, and I am falling under the category of scheduled caste, Lordship.
See, schedule cast or what was the initial argument in the or the
In the appeal, Lordship, the
in the-
TCR
in
has
the-
been called for.
in the no.
In the,
Okay, application to appear.
You are asking for stay.
no, Lordship.
No, for interim maintenance.
Interim maintenance.
Interim maintenance, yes.
Application, can application, Miller.
Little.
Yes, FA or anything like that.
Are you mentioning upon notice?
Can.
Lordship, on last date, on 20th April, the matter was taken up and the direction was passed to serve the copy of both the application can and the appeal application upon the respondent. I've served it.
And it was directed to appear, any date was given?
It was to be listed in this next available circuit. Subsequently communicating the order and the applications, I've served it upon the.
এইটা কিরকম করে হচ্ছে তাহলে? যদি ডিরেকশন থাকে আগের কোর্টে, তাহলে সেক্ষেত্রে তো তোমার হচ্ছে অটোমেটিক আসার কথা, কেন মেনশন করতে হবে লোককে?
Whether liberty was given to
Yes, given-
mention,
TCR was called for, Lordship.
LCR has come.
Lordship, I'm praying for listing of the can application.
The can application, even if can is taken, if we need to look into the lower, the district court records, then what will happen? We will be in difficulty. See, maintenance now you are aware, Rajneesh versus Neha, it has settled the law. Now, what was the affidavit? What was the consideration before the London district judge or the fast track court? We do not know. We need may require the records. Very well, you since you are mentioning it, you do you know the other side, the advocate for the other side?
In the district court, I'll communicate.
Inform you.
Yes, your Lordship.
এটাকে ইয়েতে দাও, তোমার হচ্ছে আজকে সোমবার, মঙ্গলবার, বুধবার, which district?
Darjeeling district. Lordship.
আজি বৃহস্পতিবার করুন।
Great, Lordship.
12 তারিখ।
Item number 1.
I'm for the appellate.
What is the matter about?
I'm for admission, your lordship.
Application for bail.
Praying for admission, there is a delay, condonation application also.
I filed it. Your lordship will find it. I have filed that. Can 1 is my condemnation application.
No, firstly you say what is your objection regarding?
No objection.
No objection. Appeal arises out of which order?
Order dated 6/9/2024. This is order of conviction.
Delay of how many days? Delay of how many days?
157 days.
Huh?
157 days.
E76 D120 gang rape. Two accused person. There are two accused person.
Three accused persons were
Three.
there. Here for the one named Firoz Alam.
The remaining 2 accused persons have preferred appeal. Those appeals are pending before this.
Oh. Have they been enlarged on bail?
No, their bail was rejected.
25 years. And 1 lakh. Delays.
This is an appeal
Yes, your lordship.
preferred against the judgment and order dated
Judgment of conviction and order of sentence. Judgment of conviction.
Judgment of কি বলে?
Conviction.
Judgment of conviction and order for sentence, respectively dated 4th September 2024 and 6th September 2024. Full stop. The appeal has been filed after about 157 days. Full stop. The appellant has preferred, have filed an application under Section 5 of the Limitation Act for 1963 for condonation of the accused. After hearing the parties and considering the materials on record, and particularly keeping in view that two of the co-accused have filed separate appeals, the delay is condoned and the appeal is admitted. The appeal is admitted for being heard. Since the lower court record, bracket LCR, has already been called for, in the other appeals. Give the number.
Yes, bro. CRA DB 77 of 20.
Please
Yes,
write.
yes.
Please write. Has been called for in
connection with another appeal.
being such and such. There is no requirement for calling for the LCR. Full stop. This appeal shall be heard along with the two other appeals. Being such and such and such and such.
Liberty will then to file a connecting application for suspension of this file.
That is always why you should do. The parties shall take appropriate steps for getting the appeal ready for hearing.
But usually paper books are prepared by the department.
I am thinking of paper book ওর জন্য একটা বানাতে হবে।
না ব্যাপারটা হচ্ছে পেপার বুক যদি
ডিপার্টমেন্ট বানায়।
ব্যাপারটা কি পেপার বুকটা বানাবে কিসের বেসিসে? এলসিআর এ অন্য দুটো অ্যাপিলে যদি হচ্ছে পেপার বুক তৈরি হয়ে গিয়ে থাকে তাহলে এর পেপার বুকটা আদৌ দরকার হবে কিনা সন্দেহ।
অ্যাডিশনাল ও তো মুভ করবে অ্যাডিশনাল পেপার
ওই
অ্যাডিশনাল
for that reason I have given you the parties should take appropriate steps to make the appeal ready. Including preparation of additional paper book, if so required.
Great.
Additional না দিয়ে paper book করে দাও if so required.
Yes.
Item number 2.
Because if the three appeals are heard together, then in the other two paper book directions have been given.
Yes.
If repetition and burdening the court with further same documents will not inure to anybody's benefit. If he wants to rely upon, he may prepare paper book disclosing certain documents which he intends to do that.
Not only the additional copy of the paper book has to be given to him.
Additional copy.
That.
Yeah.
Great.
Item number 2.
Yes.
The heading pair in connection with appeal. Item number 2.
Thank you.
Passover করো।
Item number 3. Item number 3.
my lord, I am for the state.
Who is for the appellant? Any idea?
নেই
দেখো তো আগের অর্ডার শিটে কে ছিল?
দেবর্ষী ধর
Mandla used to appear virtually in this matter. I don't see anyone today.
মিস্টার
Miss Mandla. Alaul. What are the accused in now? Petition.
ও দেবর্ষী ধর লার্নেট অ্যাডভোকেট দেবর্ষী ধর দেবর্ষী
Devasthi Dhar is the advocate on record.
অ্যাডভোকেট অন রেকর্ড ইয়েস
Mr. Dhar is available here. Mr. Dhar is available. Ask him. He must be either in court.
Lord, he is before Lord Justice Kant on his legs. Let him be passed through.
Passover করে দিচ্ছে। Passover. You inform Mr. Dhar.
Mal.
ও আইটেম নাম্বার 3 একজন মুভ করছে ইয়ে তানিয়া ভৌমিক এই আনমিউট করুন ওনাকে যাতে শুনতে পাই ওনার এইটা করুন হ্যাঁ ও
Yes, can you hear us? Please refresh your
Unmute.
connection.
আনমিউট ইওর ইয়ে
Please refresh your connection. We are experiencing connectivity problem from your side.
নট অডিবল
You are not audible. You are not audible. You are visible but not audible.
ও পাসওভার হ্যাঁ
Bring for not today, Miss Ashima Mandla will be there tomorrow. She'll be doing the matter.
Who?
Miss Ashima Mandla.
Oshima Mondol. Banda. Not today call. But tomorrow don't come and repeat the same prayer.
ফোর
Item number 4.
For my lord, I am for the state. Lord, this is an application for suspension of sentence. But my lord, my application doesn't contain the copy of the judgment and the evidence, without which my lord I can.
After tomorrow, Day after tomorrow. Why? Not tomorrow. You cannot give him today. Not today.
Wait.
Item number 5.
I might be above the petition of action. This is admission of appeal. Tribunal section 14, 452 of the Bharatiya Nagaric Code.
Within time. Yes.
Man has been assigned the matter yet on behalf of the state, because our policy does not contain any endorsements. Lord, let it be admitted if it is only for admission. Let it be admitted, my lord.
I will serve it tomorrow or by today evening.
So he says that if it is admitted, he does not have any objection.
Criminal appeal, it has to be admitted.
এশিয়ার কল করুন পেপার বুকে পেয়েছে
দেখুন কি
ও
অর্ডারটা কি আছে দেখুন ইয়ে দা
বাকি কেউ বোঝে নাকি IBR ৫,০০০ টাকা
Service করে তো for endorsement base শুরু করব।
বক্স
সার্ভিস না করে তার মানে সার্ভিসও হয়নি। তুমি বললি যে সার্ভিস হয়ে গেছে। তোমাকে না অফিসে সার্ভিস।
Oh, that's the matter of.
I guess. I guess.
ওই আগের ইয়েটা একটা অর্ডার নিলে না কনভিকশন আর ইয়ে this is an appeal against the order of conviction against the judgment of conviction and order of sentence. Passed on
7th April 2025 and
passed on 7th April 2025. Yes,
and 9th April.
Passed respectively on 7th,
and 9.
7th April and 9th April 2025. Full stop. The ordered impugned arises out of special C, bracket C, case number 12 of 2024 under section 6 of the
10, 6 and 10, 6 of POXO Act
section 10(6) of POXO Act পুরো কথাটা দেবে prevention of
and 55.
There is a delay in filing the appeal.
appeal arises out of
From the conviction under section POXO Act.
Section 5 file.
Because grant application is being filing today.
Oh,
Kindly place the matter.
order first.
Yeah, to-
হ্যাঁ কোনো order দরকার আছে?
If file
File it
to cure the defect. আচ্ছা, you need time.
Yes.
How,
Today it is filing. Day after tomorrow maybe
not this week?
not this. Great.
Defective এখানে ইয়ে করা আছে, defective আছে, সুতরাং to cure the defect is less for time. Accommodation to cure the defect.
the appellant seeks an adjournment to cure the defect. Full stop. We are told that the appeal is filed out of time and an application for condonation of delay is required to be filed. Let this matter appear on next Monday.
Great.
না এইটাকে করে দাও একটা কথা, এটাকে লিস্টে রেখে দি, কেন ইয়ে দিলে তো ক্যান দিলে তো এমনি এসে যাবে আবার।
হ্যাঁ। Next year, the interim review is filed. Defect will be clear to the matter.
হ্যাঁ
নিয়ে আসবে আপনি বলে বিবেচনা নিয়ে আসবে
ঠিক আছে। Next Monday, the applicant should file the application in the meantime. You are for the state?
Lordship, in item number 7, Lordship.
Item number 7.
Lordship,
Happy.
in this matter, in the earlier occasion, there is a direction for submitting the Lordship paper book.
Served upon you.
No, Lordship.
কি অবস্থা পেপার বুকের কি হয়েছে দেখো তো।
No, he will prepare it mandamus appeal.
হ্যাঁ কে প্রিপেয়ার করবে? ইনফর্মাল পেপার বুক ছিল নাকি হচ্ছে?
Devoshi Dhar is the advocate on record, Lordship.
Mr. Dhar, you ask him to come. He is present in court. We
Yes,
are passing it over. What is the matter about?
Lordship, this is relating to police inaction, Lordship.
Police
And this
inaction?
matter was dismissed by the learned court in single bench, Lordship, and being agreed against the order, he is preferred to appeal.
Police inaction in respect of civil matter, then?
Actually, their allegation is that the police was badly beaten by the lead petitioner, but despite of no action was taken. But Lordship, this lead petitioner is a habitual offender. Several cases was pending against them, Lordship. And police also, they are also assaulting the police, and over this issue, some police officers were admitted in the hospital, Lordship. So case was initiated and he is seeking for the washing and all,
Crossing under 226,
Yes.
Lordship.
Bhajanla, but there the read has been.
And Lordship, also, they are also praying for taking the action against the police who has beaten them.
We are passing it over, ask Mr.
Lord.
Dhar to come.
Item number 8.
Your Lordship, I am praying for not press because as per the written instruction of the applicants.
Okay.
What is this application or not press? What are you not pressing? Bill application, what?
Actually, in the writ petition, I am the applicant and respondent of the original writ petition. It has been ordered that illegal construction to be demolished. And after going through the documents, it has been seen that the appellants, their rights are not being hampered. Hence, they have prayed.
It is submitted by Swanso, Namta Niano, on behalf of the appellants that she has received instruction from her client for not proceeding with the appeal. Stop. The written instruction, a copy of the written instruction. Is it a written instruction you are handing over to the
Yes.
court?
They have sent me in WhatsApp and I have given the copy.
Unsigned document.
Copy of the written instruction.
Said to be given by the appellants to their learned advocate, placed before the court, is taken on record. So the appeal along with connected
No,
applications,
no,
if
শুধু appeal.
any, stands dismissed for non-prosecution. Interim order, if any, stands vacated.
It's a Devoshi now.
You have to now make an affidavit and say that from Devorshi you have become Meghna. Appearing, vanishing, appearing, vanishing.
Is 7 8? Devoshi.
Ah,
I've retired from this matter.
retired heart.
Yes, retired.
So in whose favor have you given the change? That is not the proper way. You have to know the advocate in whose favor you are giving the change.
Charge sheet has also been submitted. The case is pending before the trial.
The appeal arises out of an order dated. Same matter with it.
For 29/1/2025 lordship.
20.
March 2025.
29 January.
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 29 January 2025 passed in WPA 72 of 2025, by which the prayer for quashing of the FIR made by the appellant, who is also the writ petitioner, had been rejected. Full stop. The appeal was filed through Mr. Deborshi Dhor, learned advocate. Full stop. Mr. Dhor submits that he has given no objection and is no more appearing in this matter. Full stop. The state is represented. Let this matter appear in the list on next Monday. The learned advocate for the state shall serve a notice to the appellant, in the meantime, informing the appellant that this matter will be taken up on next Monday or 16th.
Great. Item number 9. Under random application.
I'm praying for short pass.
Yes. Yes.
There was an upon you to file opposition, my lord. We are affirming by today. And
No.
for to file opposition.
We cannot hear you properly because your
Qualification.
connectivity is poor. So your voice is not only getting distorted, but we cannot also hear you continuously. Yes, well, you are asking
For short passover.
My lord, my lord, not my lord.
Yes. Yes.
My lord, I'm behalf of
Behalf of whom?
respondent number 6. I'm for the respondent number 6, my lord. My senior is not audible, my lord. That's why, my lord, I'm paying for not today, my lord. Kindly make it not today.
Item number 9.
Item number 9, my lord. I'm for the respondent number 6, my lord.
Is there any guarantee tomorrow your
My lord,
virtual connection will be proper?
My lord, am I audible now?
Yes.
My lord,
Yes.
there was a direction to file our opposition 1 week after vacation. We are going to affirm the affidavit, my lord, by the course of this day tomorrow we will serve the copy upon the appellant so that it can appear any day after tomorrow, my lord.
Very well. Day after tomorrow.
Day after tomorrow.
Thursday.
Thursday. Great.
But Mr. Mukherjee, you ensure it. You have
My lord, I'm sorry, my lord. I will definitely.
Item number 10. My learned senior Mr. Mitra is appearing virtually.
Item number 10, I am for the respondents.
My lord, I beg to appear through virtual mode for the appellant.
Yes.
My lord, in view of the notification issued by the Government of India, published in the Gazette of India on 7th of April 2025, 3 rural banks, namely Bongio Gramin Vikas Bank, Paschim Bongo Gramin Bank and Uttar Bongio Gramin Bank has been amalgamated and a new bank has been formed under the name and style, my lord, West Bengal Gramin Bank. One state, one Gramin Bank. This is the policy of the central government. That's why West Bengal Gramin Bank has been formed. And now head office is at Baharampur. So my lord, jurisdiction is vested to the, but so far my understanding, my lord, jurisdiction is vested to the principal bench. Kindly release this matter, my lord. And my learned junior is there who will place the notification. And the new bank has started functioning from 1st May 2025.
You are appearing for whom?
Appellant.
It is submitted on behalf of the appellant that 3 regional rural banks in West Bengal as amalgamated and is now known as West Bengal Gramin Bank. আচ্ছা 3 ইয়ে হচ্ছে কি বলো তো কি বলো না 3
বঙ্গীয় গ্রামীণ
নেমলি বঙ্গীয় গ্রামীণ বিকাশ ব্যাংক, পশ্চিমবঙ্গ গ্রামীণ ব্যাংক and উত্তরবঙ্গ
ক্ষেত্রীয় গ্রামীণ ব্যাংক।
ক্ষেত্রীয় নিউলি গ্রামীণ ব্যাংক, তারপর হচ্ছে
operating from its head office located at Maharashtra.
The West Bengal Gramin Bank has its head office at Baharampur in the district Murshidabad. In that view of the matter, it is submitted by the appellant that the matter should
Your Lordship, an humble indulgence. Your Lordship, I am for the respondent in this matter. Your Lordship, this matter, writ petition was disposed of by the single bench of the circuit bench, Calcutta High Court, Your Lordship. Your Lordship, if the jurisdiction permits, let the matter be kept here because partially the jurisdiction lies on Kuch Bihar. As the Uttar Banga Gramin Bank, the head office was at Kuch Bihar prior to the amalgamation.
Uttar Bongo Gramin Bank does not have any existence now in view of the notification.
Yes, I do understand that. I do understand
now
that.
West Bengal Gramin Bank has started functioning from 1st May. Bongio Gramin Vikas Bank, no existence of 3 rural banks.
কি বললাম ইয়েতে কি বলেছি
It is submitted under that 3 regional rural banks, namely
ঠিক আছে
West Bengal has amalgamated and is now
has been amalgamated and is now known as
West Bengal Gramin Bank.
Gramin Bank. The West Bengal Gramin Bank has its head office at Baharampur in the district Murshidabad.
And has started functioning from 1st May 2020. The appellant says 2020. The appellant says that the jurisdiction to entertain this appeal is with the principal bench. Let this matter be released from the Circuit Bench at Jalpaiguri for being
What is adjudication?
for
And they were released from the circuit bench at Jalpaiguri.
for being heard by the principal bench at Calcutta.
My
The registry should take appropriate steps.
my lord, extremely grateful, my lord. Extremely grateful.
ঠিক আছে না আনিও হবে
Item number 11.
Item number 11, Your Lordship, this is a GST appeal. We have come against GST orders, Your Lordship. I'm led by my senior, Mr. Ankit Kanodia, in this matter. There was a direction of paper books. Paper books has been filed, Your Lordship. The matter is ready for hearing, but he wants
He's on the other side.
against the state. He's ready with the matter, Your Lordship, but he wants to do the matter personally, physically. But due to his health issues, he's unable to appear, Your Lordship. I'm praying for next circuit, Your Lordship. He's severely ill.
Why next circuit?
He's severely ill, Your Lordship. He's undergoing treatments and.
Yes, Mr. Shah, what do you say?
I leave it to your lordship.
It is submitted on behalf of the appellant that the learned counsel engaged by the appellant is severely ill and is undergoing treatment, and as such is not in a position to either physically attend the court or conduct the hearing of the matter virtually. The matter is otherwise ready for hearing since the paper books have already been prepared. After hearing the parties and considering the materials on record, let this matter be adjourned and shall appear before the next circuit bench, subject to its convenience.
I'm grateful, Your Lordship.
Single word or double word?
Your Lordship.
Grateful, single word or double word?
Item number 12. Item number 12. Passport. Item number 13. Item number 13.
Bablu Agarwal.
Item number 12. Item number 12.
Yes? Yes.
There was a direction about the respondent authorities to file a report in the form of affidavit in this case. That is not yet been filed.
What is the matter about? Who is for the respondent?
My state council on this ground has not come before.
Not today? Well, day after tomorrow.
This Item number 13.
Well, the appeal for the respondents. This is a state's appeal.
My state council is on report number 2. I am paid to pass over.
I'm grateful.
Yeah. Item number 14.
My lord, item 14, my lord, I appear for the appellant. My lord, may I come back tomorrow, your lordship? Item 14, my lord, may I come back tomorrow, your lordship?
Why?
My lord, I am not actually, my lord, in High Court, my lord, so it is difficult for me to do the matter right now. If your lordship kindly, my lord, keeps it tomorrow or day after, subject to your lordship's convenience. I have few documents to hand over to your lordship as well. If it could be taken up, my lord, day after or tomorrow, subject to your lordship's convenience.
Lordship, service is not effected yet. Lordship, kindly.
Oh,
When did you file it? দেখো তো কবে ফাইল হয়েছে? ডান দিকের মাথায় লেখা থাকে
14th May.
14th May. And the order under challenge was?
my lord, order on the challenge was, my lord, 20, my lord, 9.
You think I'm
May I come back tomorrow, my lord? So, kindly, my lord, I'm praying, may I can come back tomorrow or day after.
আমার সাথে আমার টিভি order under challenge dated 3rd April 2025.
Third April and you have not been able to serve it. Strategic delay.
Lordship, this is an inadvertent delay, Lordship, and there was vacation, so inadvertent delay, Lordship, kindly be concerned.
Now you serve them, it won't be possible for,
Week, Lordship, it will be served.
and we will keep all the matters in the last week. Very well, next Monday. You should be heavily penalized.
Deeply obliged, your lordship. Deeply obliged. I'm so sorry, your lordship. It was not known to me. I'm extremely sorry.
Grateful, Lordship.
Item number 15.
I beg to appear for the state lordship in this matter.
Lordship,
Saha.
may I please your lordship? Lordship, as it appears from the cost title that there is some defect. I have instructed my fellow, learned fellow junior, I had told him to remove the defect. So lordship may kindly take it up any day as per your lordship's convenient. There is some defect.
What is the defect?
Lordship, that I don't know. My learned fellow, my fellow brother is there. I can move the matter here and now. I have no problem. Only because of this thing.
আমি তো বলতে চাই এখানে করে কি
আমি তো ready.
ও আচ্ছা The memo of appeal needs to be classified in words as one paper from original order. Memo of appeal needs to be classified in words as one preferred from original order. Original order
ওইটা
means-
লিখতে হবে মাথায় ওই ইয়েতে এইখানে অ্যাপিলের সাইড
At the top.
এখানে লিখতে
At the top.
অ্যাপিল ফ্রম অরিজিনাল অর্ডার ও
Original. It is
Cure
not written
cure
there.
the defect, cure the defect. Day after tomorrow.
Day after tomorrow.
Lordship, lordship.
ডাকো ডাকো কি আছে দেখি।
Item number 16. Under order of Group 11.
ঠিক আছে এটা রিসেসের পর এটাই ফার্স্ট নেবো। Item number? Other side is there.
No.
No. Let him come, you just. Yes? No, single. Today, I think there is a 330 resolution also in the principal bench.
Item number 16, the order 41, rule 11. Item number 16.
Passover photo.
Item number 17. Item number 30.
What is the appeal again?
Appeal returning the order dated 13/6/2023 passed by the Learned Edited Third Court, demanding that the first appeal court may share in the trial court.
Yes.
Being agreed.
What is your ground?
Actually, I am the tenant was filed against me by the landlord. So this was contest on the ground of reasonable requirement. And then it was they filed the preferred appeal, and after conducting a hearing, actually at the last stage, the conducting advocate for the respondent retired from the case, and matter was heard expertly, and no opportunity was given to this appellate.
Why should one give you an opportunity or the litigant an opportunity? It's a strategic one. You found that you will suffer a degree, so the advocate discontinued.
The reasonable requirement was
What reasonable requirement? How much area are you occupying?
approximately two shop 10x22 12 and 10
To shop. What business are you carrying on?
I am repairing business.
What repairing?
Some machines, tools, etc. And landlord has having another shop room in the area.
Maybe. The law is now undergone a sea change. The judgment of 50s and 60s were pro-tenant. Now it's in the landlord. Firstly, on what ground did you resist? What was your ground of resistance?
Actually, my lord, I am the poor person. My library is running by this shop. So
Don't go by the sympathetic touches. Come to the law point.
Reasonable requirement. What was your ground to resist a degree of eviction on the ground of reasonable requirement?
Actually, the evidence adduced by on behalf of the landlord, there is no evidence or iota in favor of the landlord that the reasonable requirement is required. No evidence.
Show us. Show us. Which part?
সেই ইস্যুটাই নেই এন্টাইটেল টু ঢুকিয়ে দিয়েছে or alternative indemnity, alternative suitable accommodation.
Yes.
Actually, the ordinary judgment, para-10, page 10, reasonable requirement has been reliably stated by the trial court.
What did the trial court say?
I am reading out from the page 11 last paragraph. But the plaintiff neither is claimed nor at the time of evidence of final hearing, confident that there was a genuine need of on behalf of or to avert the events of the financial hardship and the.
Now, what is the case made out? The plaintiff has laid down evidence that he has a sweetmeat shop which is 5 foot by 4 feet.
6.
As is 6 feet. It is insufficient for carrying his business. He requires the two. What more will he say? Tell me.
Evidence is that he has another accommodation also there.
Where?
Nearby area also.
Nearby area. So you go to that alternative accommodation. I have a shop room. Did I commit any sin by letting out it to you? Now I require it. Why will you not leave? Tell me, why will you not leave?
I am all around in the room and
Can't be helped, can't be helped, can't be helped. It may be harsh, but on balance of convenience and inconvenience is, I will not say because the matter is going on, but both of you did the harikari in the matter. To establish a reasonable requirement or to defend it, what is the main evidence required?
Reasonable requirement on for the landlord. I think that has something good.
What will he prove? Tell me. He says, I have a sweetmeat shop. It is inadequate. I require more space. What further will he prove? Will he assert or prove? You have a chamber in your residence where you cannot accommodate your juniors, your stenographer, not more than 2 of your clients can come and sit. And you had let out 2 other rooms to me, adjacent rooms. Your case is that, look here, I am a practicing advocate. I require more space to accommodate my books for my clients, for my juniors, and for my staff, including the typist and stenographer. Now, I have only that space. Is it your case that he has more than that space in that building? It's not so.
It's not.
Then
Actually, for running his sweetmeat shop, there's another accommodation also there.
see, it's my prerogative. I am the owner of the property. Whether I will be operating it from my own premises or my maternal uncle's premises, that is my prerogative, that I have a property which I had let out to you. Now I require it. Question of admission will come if we are prima facie satisfied. We are not prima facie satisfied. No adjournment, sorry. No adjournment, nothing. No adjournment. After wasting half an hour time, adjournment, those days are gone. We don't believe in that. No day after tomorrow. No day after tomorrow. You prima facie satisfy us what was the lacking. Have you been able to demonstrate that he has more than one shop room at the said premises, which are let out to others? He is not asking for the eviction of those persons, but he is asking eviction of yours. He does not have any alternative at that premises. I need it for my own business. What further will I have to establish? Tell me.
Mr. Tahul Bhattaji is the original advocate, but he has asked me to, then I have come, then allow me another day accommodation, I will try to that.
See, when you opened the matter, you should have said this to us. You thought that we will be admitting it on your submission. Now you found that we are not so much inclined, so adjournment. See, we have also spent some time in the bar on that side. In the morning, I told, don't trigger my poisoned mind. I always try to leave it on that side. This is the way. What are the judgments you cited for reasonable requirement? Tell me.
One day accommodation, even I will satisfy that.
You will be able to satisfy us.
Right?
এই মামলায় যেগুলো অ্যাডজার্নমেন্ট হচ্ছে না এমন জায়গায় রাখবো যাতে কালকে নিতে পারি। কারণ আরো মামলা ঢুকে গেলে স্কিমটা হচ্ছে এরকম যে আরো মামলা ঢুকে গেলে মামলাটা নিচে চলে যাবে, আমি নিতে পারবো না বা আমরা নিতে পারবো না, ওইটা যেন না হয়। ঠিক আছে, এটা কালকে ওই উপরের দিকে দিয়ে দেবো। দিয়ে দেবো। But no adjournment on that. I will make it very clear.
Item number 18.
For the appellant, the tenant plaintiff, it's an account order lawsuit, and it be taken up on Thursday, and who done that lawsuit?
Affirmed order means?
Account order, that suit has been instituted at the instance of the appellant plaintiff is the tenant. It's a declaration suit for declaring his tenancy rights. He lost. Thereafter, the first appellate court, which was affirmed, the trial court's order was affirmed. So therefore, this is the second appellate order of affirmation.
Concurrent finding by two courts.
I'll try, Lordship. What can I do, Lordship? I'll try. Thursday, I'll do the matter.
Come tomorrow?
Not tomorrow, madam. Just today only I'll come and I'll make myself bigger to satisfy whatever extent you.
let us get an idea in what line you are trying to persuade us. Let us take an idea.
Right now,
Yes.
Substantial question of law আছে।
Because see, what is the substantial question of law? When you are coming for a second appeal, you must be ready with the substantial question of law.
the plaintiff's father was the original tenant. The landlord was the defendant's father. Now, Lordship, initially the defendants instituted a title suit.
Landlord, here the important question is, when did the original tenant die?
Yes, madam. I'm coming to that. No, my lord, initially one suit was instituted by the side of the landlord for eviction on the ground of reasonable requirement and default from. My lord, said title suit, said eviction suit was, my lord, dismissed, and the tenancy right was established in favor of the appellant.
See, who is disputing? Did the landlord ever dispute your tenancy right? Otherwise, think it logically. If I had disputed, say I am the landlord, if I had disputed your tenancy right, then would I have filed an eviction suit? My suit would be my suit would have been for recovery of possession by evicting a trespasser. So, landlord has never disputed the tenancy right. So, where is the question of your establishment of tenancy right by a competent court? There, the landlord did not succeed in proving his or her reasonable requirement. So the suit for eviction based on reasonable requirement and default was dismissed.
And no appeal preferred from that judgment.
Now tell me, if I say today I have lost a suit on being unable to establish reasonable requirement, will it preclude me from filing a suit in future on the self-same ground? If I can satisfy the court that with the change in situation, my reasonable requirement has changed. Now this is the reasonable requirement. Can I not file a suit?
This instance suit has been filed by the tenant.
Yes. And I understood the tenant, what the tenant, see, landlord suit has been dismissed. Let us forget. This suit is by the tenants. Now, what is the tenant suit? Can you get a declaration, perpetual tenancy declaration from a court?
My point is,
First you answer. Can you get a perpetual declaration that I am a perpetual tenant? Then the will be swimming against the tide, because the law is very well settled and clear. It's very. Let us forget about the West Bengal Premises Tenancy Act. Logically, think of logically. Then the statute will come into your aid or will stand in your way. Suppose the tenant files a suit for declaration of tenancy. What is the prayer over there? Should not be evicted without due process of law.
The decree for declaration that the plaintiffs are the tenant upon the property, for the decree of declaration that the plaintiffs have been lawfully possessing the premises as tenants therein, and for decree of declaration that the defendants have no right to evict the tenant or to make any attempt to take any step to evict the plaintiffs or to dismantle the premises or any portion thereof. These are the main prayers, Lordship. Lordship, my submissions before your Lordship is this.
Can you get your prayer is couched in such a manner that you are asking that I am a tenant, I should remain as a tenant, and I should continue as a tenant.
What that is lordship?
What is the point of law? We have not been able to understand till yet.
My lord, means up lodged. That is, my lord, yes, the tenancy cannot be made for perpetual, my lord. But my lord, the wife of the original tenant, my lord, she was there at the time of the death of the original tenant. So, my lord, she has no other alternative accommodations. It's a residential premises. Therefore, my lord, the limitation of 5 years as stated.
Absolutely correct. Absolutely no dispute.
Taken care of.
No, there is no dispute. To look into, read the provision.
Yes.
You will find for spouse,
Yes.
for life. There is no dispute. What has to be considered?
House is there, she is the party in the suit.
Yes.
My lord, so my lord, the proviso, the benefit of the
See,
proviso. Which is
No,
applicable.
madam, this is where you are making a mistake. You are making a mistake because there are pronouncement of our court in at least 3 matters. If I correctly remember, the first one was by the bench of Justice Jyotirmoy Bhattacharya, where it was held that you have to satisfy twin tests, that you are dependent and you are residing with. Now, for the legal heirs, it is difficult to prove they are dependent, but they can prove they were residing. For the spouse, it is more easier to prove between conditions. Have you satisfied before the court the twin conditions?
My lord, an application was made, lordship, for initially the deposition, so the spouse was not there. Thereafter, my lord.
Who is going to adduce evidence? Spouse is one of the plaintiff. If you don't adduce evidence of this,
Under order 41/27, my lord, was filed for my lord, for my lord, depositions of the spouse, but that has been rejected.
under what grounds order 41 rule 27 is attracted? Additional evidence হবে কি করে? আমি যদি
What is the gown? What was the gown?
আমার বেস্ট উইটনেস কে আমি আনলাম না বক্সে, তারপরে আমি বলবো যে আমি সুটটা হেরে যাওয়ার পর আমি বলবো যে আমার অ্যাডিশনাল এভিডেন্স দাও। Is it
Wife was, my lord, admittedly wife was
Madam,
there at the time of
madam,
death.
what is the when you conduct the suit? It is the unwritten law that you have to adduce your best evidence. Now, if you choose not to adduce evidence or not to bring the lady to the box or record a deposition through commission, why should the court assist you?
That's why I'm.
Additional.
My lord, that point I cannot improve. That has been done before the learned trial court, my lord. I cannot improve. But the thing is, there was an application under order 41 rule 27 that was rejected.
Did you challenge that order?
That order.
Your
That order,
see,
lordship, kindly consider, lordship, if your
you
lordship can see,
are flogging a dead horse.
the order has been, the order has passed at the date of delivering the judgment and order of the
Maybe.
title appeal.
Maybe you
Not
have a
separately, lordship.
maybe you have a very
Did not have the chance to file a petition against that order.
you may be correct in your submission, but end of the day, what did you do?
But at the end of the day, with the wife is the spouse is suffering, lordship. Because my lord, she has the benefit of the proviso clause of section 3G of the West Bengal Premises Tenancy Act. My lord, on that point, lordship kindly consider and act, my lord. Lordship. Because the wife is there. Wife was there at the time of death.
See, I will not put you to, we will not put you into embarrassment. You get yourself ready, day after tomorrow you come, we'll tell. Because see, if I start looking at the evidence, then you will be put into.
It's against me. But I'm telling your lordship, evidence is against me. Wife's against, the spouse evidence is not there. That has not been allowed. But it is true that the wife was there.
Maybe have you made out that case in the plaint? I am sure you have not made out that case in the plaint.
Original tenant was there. He died subsequently. Thereafter, the plaintiff,
Did
the
you-
sons and the wife has.
Madam, it is not res integra that beyond the pleadings you cannot adduce any evidence. Now, did you amend the plaint? When the original plaintiff died, did you amend the plaint? Because the cause of action was in the suit in favor of the original plaintiff. So the question did not arise of pleading about the spouse. Now, when the original plaintiff died, it was incumbent upon you to record the death and amend the ground that yes, so and so is the spouse under the provision has a say life interest. Did you now so what wrong has the learned judge committed?
That's my mother.
What wrong? Tell us what wrong as the learned judge committed. If there is no pleading in your plaint, why? Where is the question of adducing any additional evidence? Because if you look into the judgments, Katina of judgments, Bondas Singh and all those, whatever evidence you lay, if it is not in the pleading, it will not be. Even if you had laid, it wouldn't have been taken into account. Plain and simple. Yeah. Yeah. When you so
And my lord, even my lord, the wife was not been cited as witness. My lord, the wife.
see, if you had amended the plaint and taken up this point, this would have been a legal point, not a point of mixed question of law and fact. A legal point can be decided even without evidence, because if you had pleaded that I do not have any independent income and till the last date I resided with my husband, that is fair enough. No additional evidence is required. You have chopped your leg, and then you say plastic surgery should be done to allow me to walk around.
Let me go through the papers once again. Anything I'll get on it, I will try to convince your lordship. Lordship, kindly keep the matter on. One more thing. That is going to be the two suits which have been instituted at the instance of the landlord. Two suits. Initial suit, first suit business, second suit non-procedural. The issue was framed with regard to those that those suits are relevant or not in the present case. But that issue has not been dealt with in the law.
It's not required. It's not required. Why? Tell me. Landlord's cause of action was ABC. Your cause of action is XYZ. Where is the requirement?
The issue has been framed.
See, honestly speaking, you are trying to make a repair work to a polio child. If he had suffered an accident, broken his leg, then probably surgery operation could have helped him to walk around. But a polio child, you don't have the ingredients in your plate. And you are arguing that I should be given an opportunity to adjudicate him. Is it permissible? Tell me.
Maybe it's a fault on the part of the conducting advocate.
What can be done?
Benefit is there, my lord.
What can that is, see, we are,
Because of the negligence of
see,
the party.
this is a mistake. This is a mistake which you are committing. We are not sitting in read jurisdiction, that we are entitled, authorized to exercise a discretion where we find that there is a gross wrong. We are wearing the hat of a civil appellate court. Two courts concurrent finding. Unless you can show that there is a palpable mistake on the part of the two courts while arriving at the concurrent finding, we are helpless. Can't be done. This is the difficulty in civil matters. If your plaint is defective, you may lose at any stage, in the trial court, in the first appellate court, in the second appellate court, or in the Supreme Court. Can't help it. It's a birth defect. Can it be cured? Cannot be cured.
At my relative base plot. Even one line is there with regard to the 2G benefit of the spouse.
It has to be. If it is there, then you have a different ball game altogether. See, I speaking for myself, I knew exactly this will be the problem. That's the reason I asked you this question. This has been my past experience. We ignore. It may be it did not strike the learned advocate who was dealing with it, but end of the day, see, you will end up into the trouble.
No. Very. Great.
রাখো, বেশ হতো। Yes. এসছে আওয়াজ সাইড এসছে না। Yes. State's appeal.
Yes.
What? It's all right.
My lords, before she starts, I have a preliminary objection in this.
Yes.
My lords, here the impugned order was passed by an honorable single judge on 23rd September 2024.
Yes.
Pursuant to this order, my lords, I filed a representation before the department saying that you have recovered some amount from me, kindly refund that back, since the order has been set aside. They advised me to file a refund application.
Give us some more details because we won't be able to appreciate your submission.
My lords, kindly take this. Okay, very well.
Submit.
Very well.
oral.
I'll
Give us the.
in a gist, I am saying.
Yes.
So,
What was the writ petition about?
writ petition, we had challenged the adjudication order. Several
By
grounds-
the GST
by the
authority.
GST authority. Without going to the appellate court, we approached the writ court on several grounds. On the grounds on which the writ was accepted was violation of Rule 61, read with Rule 99, which mandates that before issuing proceedings under Section 73, they have to issue notices under Section 61, which is ASMT 10 notice, giving discrepancies to the
Assessee.
assessee. Now, I am not on the merits. I'll come later to the merits. My point is very simple. The writ court had passed an order in my favor. I approached to the authorities. I asked them that look, I have paid this amount, the order has been set aside, kindly refund that matter. They advised me to file a refund application. I filed a refund application. The refund was sanctioned in February and the amount I got back. Now, this entire fact they have suppressed in their condonation application. And on the same self issue, there's a division bench of our court led by Honorable Chief Justice, where the appeal was decided in the department's favor. The assessee filed a review application saying that when they had filed the appeal, they had already implemented the order. So on that point, the order was set aside and the review was allowed. This is my objection.
So your case is that the appeal has become infructuous
Since they have implemented the order,
they have
acted upon it.
they have accepted the order and thereby has implemented.
Yes, and they have suppressed this in the condonation application which they have filed.
Yeah. Why not? E.
Condonation and how much delay? I didn't affidavit.
Yes, I'll file.
Take down, take down. The appeal
Concept of return is totally different, but whatever is submitted.
very well. See, let him get an opportunity. The appeal arises out of an order dated
23rd September 2024.
dated 23rd September 2024 passed in WPA number 1899. Admittedly, the appeal is beyond the stipulated period of time, as a consequence whereof the appellant, being the state GST authorities, state goods and service tax authorities, bracketed GST authorities. কি বললাম সেন্টেন্সটা না না ওটা নয়, এই লাস্টটা কি বললাম যেটা GST
Being the state GST authorities,
হ্যাঁ
the state goods and services tax
GST authority has filed an application for condonation of delay in filing the appeal. First, the respondent bracketed assessee submits that the order under appeal has been accepted and acted upon by the GST authorities. In terms of the impugned order, refund has been made to the assessee. This aspect has not been stated in the application for condonation of the. After hearing the parties and considering the materials on record, we find that a valuable right has accrued in favor of the assessee. In objecting to the admission of the appeal. In the aforesaid facts and circumstances, let affidavits be exchanged in the application for condonation of delay being can 1 of 2025. Affidavit in opposition, tell us.
2 weeks.
2 weeks.
1 week, very well. I'm ready, Vinod.
1 week.
1 week. 3 days. 3 days. Then we could have affidavit in opposition and next by by হচ্ছে 16th হবে তাই তো 16 opposition by হচ্ছে what 16th করো with an advance copy to the learned advocate for the appellant. Either by Friday.
I'll try. I'll try.
Reply by '19. Matter to appear on 20th.
I'm grateful.
না পারলে পরের সার্কিটটা করে দিতে হবে না হলে ইউটিলিটি চোখ করেই দেখবে 5টা সার্কিট ক্রস করে গেছে
Item number 19.
আমি রেখেছি একদিন হাতে দেখি কবে
The contribution of bill filed today. Can you make it confidential?
Why in the other matter also you filed an appeal but you did not file the condemnation of the
Actually, it's not fine. Today it is fine. Can you take
day after tomorrow করে দাও
Okay. Item number 20. But I have got the applicant note. I am paying for 1 week adjournment.
Your Lordship, I am for the respondent in this present application.
File the the compromise. There is a lot of compromise going on. Trying to seize the last.
Your Lordship, actually, the matter is already at the verge of compromise, Your Lordship. On the will be submitting our terms of settlement on the next week, coming week, Your Lordship.
It is submitted by the appellant, which is not disputed by the respondents, that the parties have negotiated for arriving at an out-of-court settlement. The negotiations are in the final stage and a terms of settlement is contemplated. On the joint prayer of the parties, let this matter appear in the list on 17 under the heading settlement. But under the heading for orders.
Grateful, Your Lordships. Grateful.
Get it done. Otherwise,
Yes, Your Lordship. The terms of settlement will be submitted within the next date, Your Lordships.
see, terms of settlement, don't bring a terms of settlement typed copy. You know how the
Yes,
procedure, it has
Yes,
to
Your
be
Lordship.
by joint affidavit.
Joint affidavit, Your Lordship. Grateful, Your Lordships. Grateful.
Item number 21. Item number 21.
Am I audible?
Yes.
My lord, so far I am instructed by my instructing counsel, service has not been completed yet, my lord.
Mr. Mojumdar, why? Your juniors are not so active.
My lord, it's a very new matter. It's not 2025 matter. Only 2 months back or 1 month back it was filed. And the intervening holiday was there, my lord. And it is true, my lord, the way our seniors used to take us to task, we do not, we cannot.
Yes. Who is the junior appearing in this matter?
Mr. Dotto Prash is there, my lord.
I'm the junior.
Of Mr. Mojumdar?
Yes.
Yes. When you propose to serve? 2026?
No, Lordship. Actually, Nima Tolma is the advocate on record. I will serve tomorrow.
Thursday.
Get from her.
Item number 22. Item number 22.
My lord, I'm for the appellant, my lord. My lord, I'm praying for a week's accommodation, my lord, because there was some direction to cure the defects in the petition. We need a week's time to cure the defects and we can come back, my lord.
এই স্ট্যাম্প রিপোর্টারের রিপোর্টটা দেখো তো কি ডিফেক্ট আছে
There are two defects, my lord. One, section 5 has not been filed, which we will file in a day's time or two. And the second one is the decree. We have applied for the certified copy, which we have not received, my lord. Once we receive, we will proceed with it.
সার্টিফাইড কপি অফ দি
Decree copy of the decree, the certified copy of the decree, my lord.
হ্যাভ ইউ গট দি কপি অফ দি জাজমেন্ট দিলে তো সরকারি সম্পত্তির ক্ষতি করে সকাল থেকে অ্যাডভোকেট সাহেব বললো তারপর তুমি ওটাকে নাড়াচাড়া করলে
My lord, I do not have the judgment.
তোমরা ওটা কোথায় রাখছো ওটা ঠিক করে রাখো না হলে তো আবার পড়ে যাবে Yes.
Yes, my lord. My lord, let us come back after curing the defect, my lord. We have just applied for it, my lord, the certified copy. And we will file the section 5. within a
Certified
day's
copy, without the certified copy, how did you prepare the appeal?
time. My lord, as per instructions, my lord, I know that we have applied for it, my lord.
No, how did you prepare how did you draft the appeal? Without the certified copy, how did you draft the appeal? Tell me.
My lord, I'm not really versed with that.
See, Jalpaiguri is quite hot now. We don't indulge or willing to go for a joyride. Do you understand Bengali?
Yes, my lord.
কাঁচা কপিটা কোথায়?
I do not know, my lord.
The suit for partition,
Partition.
preliminary degree you have challenged.
Initially, it was filed in the principal bench. Thereafter, file went missing. This year, in the month of March or April, the file was traced and the matter came up in the
No, the difficulty on our part is to conceive without the certified copy, how did you draft the appeal?
No, certificate has been filed. No?
In submitting certified copy, degree.
It was filed.
হচ্ছে preliminary judgment.
আরে জাজমেন্টটা তো জাস্টিস রুমাপালের জাজমেন্ট আছে যদি ডিগ্রি না পাওয়া যায় জাজমেন্টের শেষ দুটো প্যারাগ্রাফকে ডিগ্রি হিসেবে ট্রিট করা হবে
But now the decree has been drawn up. I have applied for the certified copy of the decree. By this week, I'll be able to furnish. Kindly takes it on Monday so that I can cure the defect.
এই সিপিসিটা দিন তো সিপিসি তো আছে করে দিয়েছে ওটা দিতে হবে একটু ক্লিয়ার দিয়ে একটা
Earlier, there were without the decree, appeal could not be filed, but there is. But now it can be.
এই না Friday. Get it done by Friday.
Can you take it on Monday? I don't want to take chance on it. Can you take it?
If everybody asks for Monday, then Monday we have to see.
Then can you Tuesday?
Do it by Friday.
Let it be on Friday. If it is not available by Friday, then I shall say.
এটা শুক্রবার রাখ।
ডিগ্রি করে পরে জাজমেন্ট করেছে 2003 জাজমেন্ট
আর উল্টে ধরি তো জাস্টিস উমাফলের জাজমেন্ট আছে যে যেতে তোমার জাজমেন্টের লাস্ট দুটো প্যারাগ্রাফকে
ডিগ্রি হিসেবে
ট্রিট করবে।
But now degree has been drawn.
তবে পেলে দিতে হবে অরিজিনাল উড়িষ্যা হাইকোর্টের একটা যায়
আমার খাতাটা আনলে আমি এখন জাজমেন্টটাও দিয়ে দেবো।
ইয়েস
Grateful.
Item number 23. Item number 23.
Lordship, I have got the applicant lordship. Lordship, copy notes are on all the respondents lordship.
When did you file it?
Lordship, 24 lordship.
24. You are in which month?
June of 20.
Half the 25 has gone.
Lordship, 10 days time may be given.
10 days?
7 days lordship.
No, not an inch.
Lordship, total 19
Maybe.
respondents are there lordship.
19 you will take 19 months.
No lordship.
Why do you come with this sort of prayers before us
Lordship, 7
and
days.
invite caustic remarks?
Next Monday.
What is the appeal against all? What is the appeal for?
Lordship, this matter is drafted by my senior lordship. So he will appear in this.
No, maybe. You are the advocate on record?
Yes, lordship.
So you do not know what is the appeal, what is the matter of the appeal?
Lordship, by this appeal, lordship, we are challenging the judgment passed by the learned civil judge senior division at conjugal lordship.
In what?
Lordship.
Money suit, partition suit?
Partition suit.
Partition suit.
Lordship. Partition suit.
Partition suit?
Yes.
What is the extent of the judgment? What wrong did the learned judge commit?
Lordship, have to get prepared lordship.
এই মেমোটা দাও তো দেখি।
Lordship, there is a delay in this matter, lordship, to filing the appeal, lordship. 55 days, lordship.
এইটা দেখাচ্ছে গিয়ে ওই কুচবিহার কোর্টে আর তুই ওখান থেকে অ্যাডজার্নমেন্টে নিয়ে যাচ্ছিস।
Lordship, the title should already judgment already passed, so.
Yes. Judgment already passed, but so that they cannot execute you, you are keeping this appeal pending and showing the crocodile cup over there. এরা সব খারাপ লাগে।
ওই রিপোর্ট গুলো দেখেছেন?
না না, অ্যাপিলটা তো জন্মায়নি। There is no appeal in the eye of law. this appeal.
Lordship, there is a, Lordship, 7 days time may be given. Will
No 7 days, not even 7 minutes.
Lordship, kindly, Lordship.
No kindness.
Lordship, 7 days time may be given. I'll serve, Lordship. I'm undertaking that.
We are not so kind enough.
Lordship, 7 days, Lordship.
I will record the reasons.
Lordship.
I will record the
Lordship,
reasons.
I'll prepare myself.
No.
Then
See,
maybe
your
not
prepar-
today. I'll prepare myself.
See,
tomorrow.
preparation is not required.
Lordship,
Preparation is not required.
I'll make myself.
There
prepare.
is no appeal at the present in the eye of law.
Lordship, my point I'll submit, Lordship.
Sorry.
Lordship, one day, Lordship, I'll make myself prepare in this matter, Lordship.
After I dictate the order, you.
Lordship, kindly, Lordship, one day, Lordship. Lordship, I'll make myself prepare in this matter, Lordship.
The appeal.
Lordship, kindly, Lordship. Lordship, there is a Lordship. I am not prepared with this matter, Lordship. Lordship, so kindly 1 day's time may be given, and
Your preparation is not required. See, 14th June 2024, submitted by the Learned Counsel. You are Mr. Swarup Das?
Yes, Lordship.
Submitted
Lordship,
by. Just a minute.
Lordship.
It is submitted by the Learned Counsel for the appellants that on account of inadvertent typographical error, instead of FAT, the cause title and the heading of the appeal has been mentioned as FMAT. For enabling the Learned Counsel for the appellant to take appropriate steps, adjourn. This is 14 June 2024.
Lordship, that mistake.
Please wait.
Lordship.
Then 25th April 2025. The matter vanished off from 24 to 25. For effecting service upon the respondents, the Learned Counsel for the appellant seeks for an adjournment. List this matter in the next available circuit. Then 15th May 2025. The Learned Counsel for the appellant, you were there, submits that the service is not complete. Let this matter stand adjourned and listed such and such. Now look at the stamp reporter's report.
Lordship.
14 days delay. There is no section 5
I
application.
have filed, Lordship.
Where is it?
Lordship, I have filed. Can 1, Lordship. Can 1.
লিভ টু অ্যাপিল ফাইল করতে হবে অ্যাপ্লিকেশন ফর লিভ টু অ্যাপিল
Yes,
আফটার জাজমেন্ট সামওয়ান হ্যাজ ডাইড
Lordship, there is a 55 days delay. So I have filed.
Yes?
55 days delay, Lordship.
না, এটাও তো ভুল। ওটাও তো ভুল। কেউ যদি জাজমেন্টের পর মারা যায়, তাহলে তো সিপিসি ভেরি ক্লিয়ার। তোমার জব হিয়ারিং এর পরে, হিয়ারিং হয়ে গেল, জাজমেন্ট দেওয়ার আগেও যদি লোক মারা যায়,
অর্ডার 22 রুলস
হ্যাঁ, তো তোমার লিগাল ইয়ার্সরা চলবে। এবার জাজমেন্ট দেওয়ার পর একটা লোক মরে গেল, তো সেখানে অ্যাপিল করবে লিগাল ইয়ার্সরা। লিভ টু অ্যাপিল কি কোথা থেকে আসবে?
সেটাই লিখেছে।
Lordship, one of the.
Yes?
Lordship,
ইগনোর করে দিই।
Lordship, direction will be given. Lordship, I'll serve Lordship by 7 days. Lordship.
Why you are not served? In the month of June 2024, you took time on the plea that you will complete service. 1 year ago, you took time on the plea that you complete service. You just want to keep it pending. I am agree with my senior that you want to keep pending and take time before the execution case. What is the suit? Partisan?
Yes. Yes.
Final degree has been passed.
Yes. Yes, boss.
Most probably they are going to execute. Now you are Execution case has been filed.
Lordship, that I have.
Eh?
হয়েছে 100%.
Lordship, 7 days time will be given.
You are
In last chance, Lordship, in the 7 days, I'll serve. Lordship.
You are taking advantage of keeping.
ওই এটাকে ক্যানটাকে ডিসমিস করে দিন, ওই এটাকে সেকশন 5 থেকে ডিসমিস করে দিন, সুপ্রিম কোর্টে গিয়ে ক্লারিফাই।
Lordship, 7 days. Lordship, as a last chance, otherwise, Lordship, whatever your Lordship thinks with Lordship. 7 days, Lordship. 19 respondents are there, I'll serve, Lordship. And Lordship, 7 days, Lordship, as a last chance.
কোন ডিস্ট্রিক্ট দেবেন?
Coachbihar.
The parties are all parties and suits sutarang dependent also in Coachbihar.
Yes.
Yeah?
Yes.
So 1 year you could not. You did not.
I did.
It is not you could not, but you
Then
did not.
serve the advocate appearing in the
Whatever.
Lordship.
No. Solve them.
Lordship, Monday, 7 days.
No 7 days. Friday.
A speed post time.
Why speed post? Why speed post? They reside in your same premises and service.
Lordship.
Speed post, you send it by messenger as also by speed.
Lordship.
এটা অর্ডার রেকর্ড করো, নাহলে সুদ রবে না, জানো তো। In a partition suit, now this appeal arises out of a partition suit. The appeal was দেখো
Partisans were preliminary degree or final degree. Whether you have challenged preliminary degree or final degree.
Final degree.
Final degree.
Schedule.
Let's see.
Suit dismiss করে দিয়েছে।
Suit dismissed. Partition suit dismissed.
না partition suit না, suit for partition and specific declaration.
Oh, suit dismissed. বলো?
This appeal arises out of a partition suit.
Whereby the same has been dismissed. The appeal was filed, or appeal was presented in the department on 23rd April 2024. The report of the stamp reporter clearly states that the appeal is beyond time, and as such, an application under section 5 of the Limitation Act 1963 was required to be filed. Poster.
We have filed it. We can one.
The section 5 application was filed on 3rd July 2024. 24. The matter came up before the circuit bench on 14 June 2024, when the same was adjourned in the presence of the adjourned on the prayer of the learned advocate for the appellant. The matter was again adjourned on 25th April 2025 and again on 15th May 2025 on the ground that service has not been effected on the respondents. It is unfortunate to note that a plaintiff whose suit has been dismissed. Unfortunate to note that the plaintiffs whose suit has been dismissed has been so casual in approach in preferring an appeal and conducting this. More than 1 year has elapsed. The service has not been effected
By Monday.
or on the respondents. Despite the matter being adjourned to enable the learned advocate to complete the service. As on date, there is no appeal in the eye of law. Since
By Friday, Lordship.
Since the-
Lordship, I am
since
undertaking
the-
Lordship as a last chance.
since
Lordship.
eye of law, since the delay has not been condoned.
Lordship, by Friday, Lordship, I'll serve by hand, Lordship. I am undertaking, Lordship. Lordship, I'm promising, Lordship.
You have come before a wrong
Lordship,
bench.
by Friday, Lordship, your Lordship has expressed your Lordship's mind,
You have
Lordship.
come before-
By Friday, Lordship,
You
as
have
a
come-
last chance, Lordship.
The-
Lordship, I'll serve, Lordship.
the stars do not click every time. Your star clicked at the initial stage, but you have come before a wrong bench.
Lordship, as a last chance, Lordship, kindly, Lordship. Friday, Lordship, otherwise, your Lordship, whatever your Lordship thinks fit, Lordship. Lordship, in Friday, whatever your Lordship thinks fit, Lordship.
Last day of the
Lordship.
Mr. Chaudhary. We know exactly what has happened. And that's the reason Mr. Das is
Lordship,
trying to make a last endeavor.
Last ditch attempt.
starts together one or something.
As on date, there is no appeal in the eye of law since the delay has not been condoned.
Full stop. Although we were minded to dismiss the matter, yet for the ends of justice, we were minded to dismiss the matter in view of the conduct of the appellants as recorded here in the above. Yet for the ends of justice, the appellants are given a peremptory chance to serve the respondents by 16th. Let this matter appear on 17th.
Grateful, Lord. Grateful, Lordship.
দেখো আর একটা ডাকো আর একটা ডাকো
Item number 24. Item number 24.
Item number 24, there was a direction for service. I have served, Lordship, but the affidavit was served not ready. Lordship, kindly take over tomorrow, Lordship.
got this time entire bond.
Service is
No, entire morning you could not affirm. If the affidavit of service is not affirmed by the client, your clerk will be affirming it. So he could not affirm it from 10:30. Not today, করো এমন গল্প শোনায় না মানে করো দেখি
Item number 25. Item number 25.
Pronoun for the appellant.
Yes, what is the
So
appeal?
there's a delay of 440 days.
440 days.
Yes, no, because time was lost before the wrong forum. This is a challenge against a degree of eviction. The appellants firstly approached the court of the learned additional district judge at Shiliguri. So time was lost there, and eventually,
No. Was it a strategic filing?
Milord, that I'm not aware of because I was ultimately appointed.
See, what is the value of the suit?
So, suit for eviction about 1,32,000.
Suit value 2,34,500.
Yes.
So, there is a judgment, if I correctly remember, delivered by Justice Bhattacharya, Bhaskar Bhattacharya. Then this repetition of the same by Justice Subrokamal Mukherjee, 150 directly, 1,50,000 directly to the High Court.
The act is there, Bengal, Agra and Assam Civil Court.
Based on the act, then why should we not conclude or come to a conclusion that this was a strategic filing?
No, my lord, I would beseech your lordship to not come to that conclusion because there was an apparent, my lord, wrongful legal advice, and because
when did you file it before the
district judge? Yes.
district judge?
That was filed right after, 1 month after the decree was passed on 10th of May 2023.
There must be, if it is beyond 1 month,
yes,
from the same court.
No, my lord, it was within 1 month.
Oh.
So that was, my lord, rightly filed as far as limitation is concerned. But
when did you ultimately get it?
My lord, it was withdrawn on 27th of February 2024.
Withdrawn with?
Withdrawn with the liberty.
Liberty?
To approach the rightful legal forum.
Rightful legal forum.
Yes, sir.
If you want to get the benefit of section 14, the twin tests are to be satisfied.
Yes, sir.
That you are proceeding bona fide and before a court without jurisdiction. How do you establish your bona fide?
Lord, we are deciding an application for limitation, condonation or delay.
Everything has to be gone into.
Lord, the
delay is 404 days.
Yes, 440.
440
40,
days.
yes.
440 days. It's not a
Lord,
40 days or 14 days delay.
No, Lord. 440 if we take it from the date of the decree passed. But if the intervening period is, my lord, set off, then the delay comes down to a lot less. Because time was lost before the wrong forum. So if that is set off, my lord, then the delay comes down.
Where have you pleaded? Section 14 benefit?
Lord, I have not pleaded.
In section 5 application that has to be pleaded.
Lord, there is a pleading that time was lost before the wrong forum, but not specifically with the particular section.
How do we interact in your application?
Kindly takes up the application.
I'm sure I'm not required to. I can tell you what is your pleading.
Yes. My lord, para 5 onwards.
Yes.
Para 5.
Read out para 5.
I'll read out from para 4 onwards, my lord. The appellant thereafter, under apparent erroneous legal advice and misconception of law, preferred an appeal against the judgment and decree dated 16/3/2023, passed entitled suit such and such, in the court of the learned additional district judge, first court, at Shiliguri on 10/5/2023, being titled appeal number such and such. The appellant ultimately, after apprising himself about the law relating to the issue, filed a detailed petition for withdrawal of the aforesaid appeal, wrongly instituted in the court of the learned additional district judge, first court at Shiliguri.
When did you have the incarnation?
My lord, this was on.
No, in your pleading you have not said so. Your pleading is simpliciter subsequent.
Yes,
but when?
My lord, the annexure is there. Annexure C.
That is the application you filed.
Yes.
You repeat your stay here.
The appellant, after apprising himself about the law.
After apprising himself. When did he apprise himself?
No, during pendency of that particular appeal.
Where is the statement?
My lord, This has to be read in conjunction with the
Sorry,
earlier paragraphs.
sorry.
My lord, when the appeal was pending,
You want the Supreme Court judgments, you have to explain.
my lord, then I'll come up with an amendment of this appeal.
You have to,
Kindly grant me that leave.
you have to explain the entire delay.
Yes.
Then,
But some
very well, then what happened?
Yes.
When did you get it?
That the Court of the Learned Additional District Judge, First Court, had been pleased to pass an order on 27th February 2024 entitled Appeal such and such, thereby granting withdrawal of the misconceived appeal as dismissed for default and disposed of. That subsequent to the aforesaid allowance of withdrawal, the appellant resolved to appoint a counsel afresh to agitate the issues.
No, if it is withdrawal,
Yes.
then the provisions of Order 23 will come.
Yes, my lord.
Where is the
No, the
leave?
appeal is withdrawn, not the suit.
No, appeal is withdrawn.
Yes.
Where is the liberty?
Yes, my lord. That
Where is the liberty?
that is there.
Then-
My lord, I was under an app, my lord. That
You see, look into the Order 23.
Yes, yes.
It's very clear.
Lord, this liberty may be kindly granted.
What liberty?
Let me contest the appeal, but it's a delay, my lord.
See,
It is apparent on the face
see,
of the record that I have
I-
lost time before the.
See, we don't have any hesitation because fault on the part of the advocate should not make the litigant suffer. But the litigant has to come up with a clear case. Now, you do not obtain a leave.
All of that was not done.
When you do not obtain a leave, you are hit by the provisions of Order 23. Then you say you need the relaxation or the benefit of Section 14. There is no pleading to that effect. How do we grant you?
But kindly takes a liberal approach, my lord, condones the delay, my lord. I'll face the consequences in the appeal. In the ultimate.
File a supplementary affidavit.
Sure.
Without any.
27th February. 27th February.
You're gone.
The order.
No, without any leave. We have seen page 33.
Now to page 33.
My lord, I've
You know it.
Sorry. Take down.
আমিও দেখি ফেললাম
The appeal arises out of. No, this is an appeal by the tenant.
Yes, by the time.
By the tenant in an eviction suit. Challenging the decree of eviction passed against the said appellant. Full stop. Initially, an appeal was preferred before the Court of the Learned District Judge at
My lord, additional district judges first court.
additional district judge, first court. No, it has to be filed before.
In Siliguri, there is a concurrent jurisdiction before the additional district judges.
Was filed before the Court of the Learned additional district judge. Auto court.
First court, Siliguri.
First court, Siliguri. Subsequently, it was found by the appellant that they said court did not have the jurisdiction to hear an appeal arising out of a suit which is valued, or which was valued at rupees 232,000. 2,32,000.
Yes.
650.
2,34,650.
The appellant therefore withdrew the appeal কোন পাতায় দেখলে 23 পাতায় না 33
33.
Order date কোথায় তো order date কোথায় তো
27th February 2024.
At the top.
The appellant therefore withdrew the appeal.
Withdrew the appeal in the order dated 23rd কত জানো
27th February 2024.
24, while allowing the appeal to be withdrawn, no leave to file an appeal on the self-same ground was allowed. The appellant has preferred this appeal before, filed this appeal before this court on 7th October 2024 with an application for condonation of delay. In order to get the benefit of Section 14 of the Limitation Act 1963, the appellant was to is required to satisfy the court that the appellant was proceeding bona fide before a court without jurisdiction. Even if this benefit is given to the appellant, then also the recording in the order dated 27th
February 2004
stands in the way to grant the same in view of the provisions of Order 23 of the Code of Civil Procedure 19
Rule 1.
Order 23, Rule 1 of the Code of Civil Procedure 1908. In short, CPC. When leave was specifically refused, allowing the appellant to prefer an appeal on the self-same ground.
No, he withdrew the appeal without seeking any leave.
ঠিক আছে কি বলো
Even if this benefit is given to the appellant, then also the recording in the order dated 27 February 2020 stand in the way to grant the same in view of the provisions of order 23
Rule 1.
Rule 1 of the civil
Code of Civil Procedure 1908. When the appellant withdrew the appeal without seeking specific leave
The leave was sought for, but that was not granted. Leave was sought for.
তাহলে ওইটা ইয়ে করে দাও ওই যে আগে ছিল সেটাই করে দাও
তাহলে আগেরটাই করে দিতে হবে।
হ্যাঁ
when leave was specifically
refused.
Leave was specifically refused, allowing the appellant to prefer an appeal on the self-same ground.
Self-same ground. In the aforesaid facts and circumstances, we do not find any merit in the application for condonation of delay being can such and such. Can one, type of can one is therefore dismissed since the delay is not condoned. The appeal is not born in the eye of law and as such not entertained. নম্বরটা দিয়ে দে applicant AFMEQ is not in defect.
Grateful.
ক্যানটা তো লিমিটেশনে গেল আমরা ক্যানটা ডিসমিস করলাম লিমিটেশনে আমরা কিন্তু মেরিটে যেতে পারি না সেই জন্য অ্যাপিল নট ইজ নট এন্টারটেইনড
Before Malad rises, Malad, but my item is 38, Malad. I do not want to embarrass myself, Malad. From Wednesday, Malad, I will be out of town this week. Your lordship is even suffering with this case, Malad. I have to go to LB Post, my personal difficulties. Is it tomorrow or Malad? I do not want to seek adjournment. Then kindly fix it, Malad. If it is not possible tomorrow, then Monday.
Let us see. You ask your junior to be
Malad. That's why I do not want to embarrass myself, also your lordship. Okay.